Hi, everybody. Good evening. Thank you for joining us tonight for another NWCLC webinar. Today's webinar is Making Your Lemon into Lemonade. It says 5:30 p.m., but as you know, it's 6 p.m., so you're right on time. My name is Alyssa. I'm the staff attorney here at Northwest Consumer Law Center. I specialize in auto fraud, so this is kind of my thing, but I'm super excited to share a bit of my practice here with you. I'm also very excited to introduce our other speaker, Alysa Mo. Do you want to wave, Alysa? There she is. She's so great. She's one of our fantastic interns here at NWCLC. We'll both be talking to you tonight about our automobile practice, about auto fraud, and how to tell if you have a lemon and what to do next. If you have questions during the presentation, please enter them into the chat box on the right side of your screen. We'll be answering questions at the end of the presentation. This session is being recorded and will be available on our website. Attending this webinar does not create an attorney-client relationship. This presentation will provide legal information. It is not a substitute for individualized legal advice. If you are seeking legal advice, we recommend that you contact NWCLC after this webinar. Information on how to apply for our services will be posted at the end of the webinar. And with that, let's get started. Alrighty, so here we go. What we'll be covering today, we're going to talk about how to notice an issue. It might seem straightforward, but depending on the issue and depending on your familiarity with vehicles, you might need some tips. We're also going to talk about lemon law. We'll help you figure out if you have a lemon or not. And we'll also go into what we call squeezed lemons, which is our fun term for used vehicles. As you'll learn, lemons traditionally are new vehicles, and squeezed lemons are used vehicles. And with that, I just want to set the scene here about vehicle defects and about dangerous vehicles that are on the road. So the three biggest problems in the auto industry right now that are affecting normal customers, normal consumers like you, the number one is vehicle defects and failure to disclose the true car condition. So a lot of car dealerships, usually the smaller ones, not the big ones, the smaller ones will buy cars off of auctions, or they'll get it from just, your average Joe, your average Jane who wants to get rid of their car. And usually there aren't really good documentation that says what has happened to the car. So a lot of the dealerships don't even know, but they should know before they sell it to you if the car is safe or not. So it's a very big common problem. The number two issue is deception or fraud in financing applications. We will probably talk about that in another webinar. That's a whole nother thing, but very popular, unfortunately, problem as well, where people will agree on a 3% financing and then all of a sudden they have a 6%. So that is a problem that NWCLC does take care of. Keep that in mind, but we won't talk about that today. And the third issue is misrepresentation or fraud in advertising, pricing, or warranties. Again, that's another issue that we cover. We cover everything, but we're not going to talk about that one today. But it is an auto fraud issue that our firm does take care of. And with that, here we go into tips for noticing the issue. Okay, so what steps should you take? Let's say you buy any car. It could be a new car or a used car. And 2 or 3 days later, after you leave the lot, you notice something is wrong. So the first thing you should figure out is it a cosmetic or a mechanical issue? So cosmetic means it's the outside of the vehicle. It's a scratch on the paint, or it's a ding on the bumper, or cosmetic could be considered something something that doesn't have to do with the functionality of the vehicle driving. So if it's like the air conditioner doesn't work, or the heated seats don't work, or the stereo doesn't work, that's considered cosmetic. And those will be sort of lower value, less expensive fixes that should be easier to get done. If it's a mechanical issue, like the transmission is shot, or the engine is broken, or your alternator isn't working, then you got a bigger problem, and you want to make sure you get that checked by a professional. So step one is to document. Take pictures, especially if it's cosmetic, if it's a ding on the bumper, if it's something that you can take a picture of, like a scratch seat, if it's supposed to be leather seats, take a picture of it. If you can't take a picture of it, like it's an engine issue, then don't. But you should take it in as soon as you can. Don't let these things linger for too long. If you talk to the dealer and you have communications with the dealer, make sure you save those emails, save those texts. Even if you just have a conversation with them on the phone or in person, it's good to just have your own little written record. You could just keep a little notebook or send yourself an email just so that there's a record of when that conversation took place. You should also make sure to save your receipts. If you end up paying for anything on your own out of pocket, save your receipts, because if you end up having a case, we could get back those costs for you, or we'll try our very best to do that. So step two, oh God, okay, sorry, my apologies. I can't, it's like blocking the screen. Step two, get a second opinion at a repair shop, preferably ASC certified. There are a lot of repair shops out there. Some of them have certification, some of them don't, but they will tell you if they are certified, because usually it'll cost a little more. But most places will do a free estimate for you. If you agree that you might get your repairs done there, they might do it for free, or they're just good people and they'll go ahead and give you a free estimate. Some places will charge you maybe like $10 or $15 to do an estimate, but it's a good idea to get a second opinion at a shop before you go back to the dealership to let them know what's going on. Make sure you hold on to that estimate. Once you get the estimate, the next step is to go back to the dealer and let them know what's going on. Let them know, hey, like, you didn't tell me there's a problem with, the headlights. I went to a shop. The shop says it'll cost $200. Can you fix this for me? And you go from there. Hopefully, if it's a low price item, typically they will do it for you for free. They might want to do it within their own repair shop. Instead of, letting you go out somewhere else, they might say, oh, this other shop is too expensive, but we'll do it for you for free. That's your choice. You can let them do it or not. But that's kind of the perfect, easy way to deal with these issues. If you have cosmetic issues, typically it'll go that way. If you have more expensive mechanical issues, then the negotiations will probably not go as well. I hope it goes well for you. If it doesn't, we are here for you. So I'm going to hand it over to Alysa, who's going to explain what lemon law is.
Thank you. All right. Oh no, I can hear myself.
Can you hear? I can hear you.
Hello? Perfect. Okay, I think that's good. All right, hi. Like Alyssa mentioned, there are generally two categories of vehicles that we deal with in auto fraud. And at NWCLC, we tend to deal more with cases regarding used defective vehicles, but I'm going to go over some information on lemons. So, put simply, lemons are new cars. So, they're either made this year or the year prior, and they've had no previous owners. And they have defects in the manufacturing. So, they fall under different rules other than normal defective vehicles. But more formally, lemons are considered to be vehicles that have one or more substantial defects that have been subject to a reasonable number of attempts to diagnose or repair the problems under the manufacturer's warranty. But that's a whole mouthful, so let's break that down. Substantial defects are anything that can be a serious safety risk or threaten the value of the vehicle. So this includes defects that create risk of fire or explosion, impaired reliability, or just defects that seriously impact the resale value of the vehicle. Now, reasonable number of attempts can vary depending on the severity of the issue. So if you look at this chart that we have up here, you can see the 4 different scenarios that may apply to define the reasonable number of attempts given the severity of an issue. And the first one there is where there's a safety defect and repairs have been attempted 2 or more times unsuccessfully, with one of those attempts occurring during the eligibility period. And that's something that we'll go over in a little bit. The second is the exact same conditions, but there have been 4 or more unsuccessful attempts to fix the issue. So the key difference between these two will be how severe the issue is. The third is where there are multiple defects and the vehicle has been out of service for 30 days and there has been at least one attempt to fix each defect. And the fourth one takes place over a 12-month period where there have been 2 or more defects in the vehicle, each of which has been subject to diagnosis or repair 1 or more times, and where at least one attempt for each of those fixes occurs during the period of coverage of the manufacturer's warranty and the eligibility period. So the third aspect of the definition of a lemon is manufacturer's warranty. And one of the things that makes a lemon is that it needs to be sold with warranty from the manufacturer. So that means that even if you buy like a shiny, brand new 2021 vehicle from someone on Craigslist, it might not count as a lemon because it needs to have the manufacturer's warranty. Right. So when you're looking to purchase a vehicle, there are 2 very important phrases that you should be familiar with. The first one is implied warranty of merchantability. This is an implied warranty that every single car sold in the state of Washington has. And it means that when you buy the vehicle, the seller guarantees that it's fit for ordinary driving purposes for a reasonable amount of time, that the vehicle is reasonably safe and without substantial defects, like we discussed earlier, and that the vehicle is of average quality of similar cars that are sold under similar conditions by other sellers in the same price range. That second phrase is as is, and this tends to be kind of a gotcha phrase that sellers like to use when they know that there are issues with a vehicle that they're just trying to get rid of. And buying a car as is means that you're purchasing the vehicle in its existing condition without warranty. But sellers can only sell a vehicle without any warranty whatsoever if they meet 2 conditions. The first one is that they have to get you as the buyer to willingly and knowingly waive the warranty. So that means that you have to explicitly agree to waive the implied warranty of merchantability. And the second parameter that they have to meet is that they need to provide a statement of the nature and the sections of the car that won't be covered under any warranty of any kind. And if you look at this little diagram we have here, it's there to illustrate kind of the relationship between you as the consumer, the dealership, and the manufacturer. So typically people purchase vehicles from dealerships, which work directly with manufacturers. So take, for example, Toyota Tacoma. Toyota, as the company, is the manufacturer. They're the ones who make all the cars and make all the parts, but Toyota Tacoma is the physical dealership where you're going to go to purchase the vehicle. Now, if you're having issues with a used car that you purchased from the dealership, you're going to be dealing directly with that dealership. But if you have a brand new car and it has some manufacturing issues and it can be classified as a lemon, you're going to be dealing with the manufacturer. And the dealership might just act as a middleman in that situation. So the repairs might be done at the dealership, but it's the manufacturer's duty and responsibility to make sure that those repairs are made. And that kind of leads us to our next point of who can do what. So let's say that you find that you do have a lemon and you're asking yourself, what can the manufacturer do for you? So the manufacturer has to repair the nonconformities and the defects if it falls within either the warranty period, which is exactly what it sounds like. It's the time period stated on the warranty, or the eligibility period. So that's either 2 years after the original date of delivery to the consumer, or within the first 24,000 miles of the vehicle's operation, whichever one comes first. Now, there are some instances where the manufacturer can't fix the issue, so they have to either repurchase or replace the vehicle under Washington lemon law if they're ordered to do so in arbitration, which is a process that we'll explain in the next slide. And so when they have to repurchase it, this includes not only the purchase price that you paid, but the collateral charges and incidental costs. However, the manufacturer may require you to pay for something called the reasonable offset for use. And essentially, if the car had issues, but you were still able to get about 10,000 miles of use out of the vehicle, they will perform a calculation to determine how much you need to pay them because you were able to get use out of the car. However, if the manufacturer fails to do repairs, I guess we're talking about arbitration on this slide, you have to turn to a certain type of alternative dispute resolution called arbitration. So this is essentially where you and the other party sit down in front of another person, or the arbitrator, and you each explain your side, and the arbitrator determines how the matter is going to be settled. And this sounds a lot like going to court, but it's different from going to court in some very key ways. The first one is that arbitrators are typically not sitting judges. They can be retired judges or attorneys, but they're typically not the judge in the way that we would typically think. And the second way is that you don't have to have an attorney there to represent you. You can represent yourself in an arbitration. But one thing that you need to keep in mind is that the arbitrator's decision is typically binding. So this means that unlike if you took the case to court, you can't appeal it, and the arbitrator's decision is final. And we have written on here hidden clauses to remind you that in a lot of contracts, arbitration clauses can kind of get hidden and they get overlooked. But it's really important to make sure that you look for the arbitration clause and see what the terms are, because arbitration is a very costly process and you want to make sure that you're not getting saddled with those charges. Also, if you want to file a request for arbitration, it has to be received by the Lemon Law Administration within 30 months of the original retail delivery date. So it's important to note that the retail delivery date is the date that the vehicle was delivered to the dealership, not the date that you purchased it from the dealership. And it's especially important if you're attempting to file this in time, because that date might have actually started earlier than you think it does. And there are some instances where you need to file a complaint, but this tends to happen more with used cars than with lemons. So like we discussed earlier, you wouldn't be raising an issue with the manufacturer, but with the dealership. So if the vehicle is missing important safety requirements like the ones we have listed here, you can file a complaint against a dealership with the Department of Licensing. And the law requires that dealers sell vehicles with these listed safety requirements. So if you submit a complaint, the Department of Licensing will investigate and make sure that the dealership is doing right. All right, now we're going to go into a bit of a hypothetical situation to help you visualize what it will look like from beginning to end of discovering you have a lemon. So let's say that you purchase a 2020 Subaru Outback from a dealership, but then 2 days later, after the purchase, the engine dies. The first step that you should do is go to your local auto shop and get a diagnostic. So this is kind of like what Alyssa was talking about earlier. A diagnostic will just state everything that's wrong with the vehicle, and it's important that you save a copy of this. The next step is to locate all the documents from your vehicle purchase, so especially the warranty paperwork, so that way you have evidence of any warranty, especially against the manufacturer. The next step is to inform the dealership of the issues and to have them put you in contact with the manufacturer. Because again, like we said, since this is a lemon, it's the manufacturer that owes you that duty to help you repair the vehicle. And again, like Alyssa mentioned earlier, you want to make sure that you're saving screenshots of all your conversations. So if it's text messages or emails, and if you do have this conversation over the phone, it is a good idea to send both the dealership and the manufacturer an email afterward, kind of recapping everything that was said. And if you can, get an email back from them agreeing that those are indeed the terms or it's an accurate representation of what was discussed. And the next step is to give the manufacturer 2 to 4 chances approximately to repair, refund, or replace a defective engine. And again, the number of attempts will vary depending on the severity of the issue. And the repairs, again, might be done at the dealership, but it's the manufacturer that's responsible for them. But let's say that the manufacturer fails to meet their obligations. The next step that you can take is arbitration. So you are going to file a request for arbitration within 30 months of that original retail delivery date. And you're going to appear at the hearing and identify the basis for your claim. So that's the type of defect that you have. And then after both sides kind of plead their case, the arbitrator will make their decision based on the information that was presented. And then both sides must comply with the arbitrator's decision. And that's all we have regarding lemons. So now I'm going to turn it back over to Alyssa, who is going to tell you more about used vehicles.
Alysa. Let's talk about these squeezed lemons. We're calling them squeezed because they're not fresh anymore. These are cars that are more than a year or two old. It might be a new car to you, but if it has a previous owner, one previous owner is enough. If it has more, then it's even more squeezed. But these are typically the cars that most of our clients get, squeezed lemons. So what you should learn about, some of this is before you even buy the car, but you should take a good look at the Carfax. A lot of dealerships give these out for free. Just so you know, the Carfax is not complete. Don't rely on it 100%. Carfaxes get their information and data from other dealerships and from insurance companies. So, for example, if the car you're looking at got into a minor fender bender, and let's say the previous owner didn't want to call their insurance, they just didn't want to deal with insurance, well, that's not going to be listed in the Carfax. So it's a good idea to use the Carfax as a tool, but don't rely on it completely. You should also try to get a copy of the dealer inspection. Some dealerships will tell you, oh, the car's great, car's fine. You know, our mechanic, our in-house mechanic checked it himself or herself. And, you know, you really should ask them, hey, can I get a copy of that inspection? Can I get a copy of that report? Because, you know, they could be lying to you. Who knows? But if they do inspect it, take a good look at that document, check the date on it, see how long ago it was inspected, and just make sure you're fully informed of what you're buying. The next thing to keep an eye out for is if you were provided notice of the defect. Sounds like most dealers would not want to tell you, hey, this car you're buying has an engine problem. They usually don't do that because they want you to buy the car. So keep in mind what they tell you. You know, you should ask them questions. When was the last time this car was taken in for service? Try to get out those answers from them. But if they tell you this car is in good condition and it breaks down, well, that's essentially fraud. They pretty much lied to you, right? So that's when you can call us and we might want to hear more about your case. Other things to keep an eye out for these used vehicles, the IWM, the implied warranty of merchantability, still applies. Any car sold in Washington must be number one, safe to drive. And this is basic stuff. This is airbags, seat belts, and brakes, pretty much. Safe to drive, and also it actually has to drive. Because what's the point of buying a car if it doesn't move from point A to point B? So if you have a car that stalls or a car that rumbles and is scary to drive, then you might have an IWM claim. Dealerships are required to sell you a car that is both safe and able to drive. So if one of those things, one or both, hopefully not both, but if one or both of those apply, then you might have a claim against the dealership. Also, warranties. A lot of dealerships want to sell you add-ons, all kinds of add-ons, which we'll talk about in a different webinar. There's so many, but one of them are service contracts. Usually dealerships have partnerships or they have exclusive contracts with service companies, and you know they get a little cut if they sell a certain number of service contracts. So if that's something you're interested in, then go for it. If they breach the service contract, or if they tell you this service contract covers everything, and then it turns out it doesn't cover everything, well, then you might have a case that you can bring to us, because that would be another occasion of fraud where they should have told you the truth and they didn't. That's actually negligence, but Either way, keep track of the warranty documents. If you buy a service contract, they better give you the documents when you leave the dealership. You should know exactly what is covered in that warranty and what isn't. And again, think about the type of the issue, if it's cosmetic or mechanic. We talked about that earlier, but keep in mind again, with used vehicles, it's more likely you're going to have mechanical issues. It's also more likely that you'll have cosmetic issues. This is just normal wear and tear of a car. As a car gets older, you know, things like potholes, things like, you know, little dings here and there just start to add up. So just keep in mind of what exactly you want to get fixed from the dealer and what you're okay with letting go. Another big thing to keep an eye out for is, when did you notice the issue? Did this happen the week after purchase? Did it happen a month later, a year later? For us, the statute of limitations for a lot of these things is 1 year. And for the cases where it's beyond 1 year, it's unlikely that our firm will take it, mostly because, like we said, wear and tear of a car happens pretty quickly. So if you notice an engine problem 2 years after you bought it from the dealership, it's probably not gonna happen there. You probably won't have a claim. If you have it within several months, depends on how serious the case is. So if you're not sure, you're always welcome to call us and ask us, and we'll let you know if you have a case or not. So just like we described before, after you notice the issue, after you document the issue, you go to the dealership. Same thing. This is what you do for a used car. Let's say negotiations fail. Let's say the dealership does not want to pay for the new carburetor or the new transmission that you need. That's several $1,000s. Well, you need to consider how expensive this is. And that will be very easy if you got an estimate, which you should have done as soon as you notice there was something wrong with the car. The estimate will tell you exactly how much the issue is worth. If it's a couple hundred, maybe it's not worth it. If it's a couple thousand, it probably is worth it. It also depends on how expensive the car was that you bought. If you bought the car for 5,000 and the fix is 2,000, it's probably worth it to bring it to us and let us know, because that's a very, very costly thing for you to pay out of pocket. And we put there mechanical defects versus cosmetics. So if it's mechanical or safety, like we mentioned before, you probably will have an implied warranty of merchantability claim. If it's cosmetic, like a stereo is broken or your radiator's broken, or, you know, nice fancy things like, you know, backup camera or something, then it's probably a cosmetic defect and it won't fall under safety or drivability. Those are fun doodads that we love, but won't be covered under the IWM. So cases that we love here at NWCLC, things that we love, good documentation. This is an attorney thing, but it's so important for us because we need proof of everything. So if you pay for anything out of pocket, save it. If you get estimates, save it. If you have communications with the dealership, save everything. And then when the case is over, hopefully it's a good result, you can get rid of all the paper that you don't need. But in the meantime, save everything in a little folder so we can take a look at it. The more recent the issue, the better. Again, like we said, that's for evidence purposes. If the car has been sitting in a lot or sitting in your garage for 8 months, and then you let us know there's a problem, it's going to be very hard to say that it was the dealership's fault and not just the car stalled in your parking lot for 8 months that was the problem. So the sooner you bring it to our attention, the better. We love IWM claims. We don't love that consumers have this problem, but it is one of the most popular claims that we bring against dealerships. So we have a lot of experience with that. Misrepresentation, fraudulent actions are pretty common too. Again, if you remember what the dealership said to you, it's always helpful. If you have communications like text, that's great too. Any sort of proof that shows that they lied to you is something that we're interested in. We're also interested in breach of contract or warranty. So again, as mentioned before, if they tell you the warranty covers XYZ, turns out warranty doesn't cover anything like that, then that's essentially a breach of contract. So we'll cover we'll cover those claims as well. All right. So we are here for you, just to let you know. So if you qualify for our services, we'll provide a free consultation. We are a legal aid nonprofit. So we have certain income restrictions on who we can represent, but we'll let you know if we can represent you or not. If you don't qualify, we might be able to provide a referral. Again, just case by case basis, depends on your case. When you're preparing for a consult, we'll probably ask you for copies of all the documents. We're all digital here, but if you want to mail it, you can mail it. A lot of us get email as well. So if you can scan things, super. If you want to take pictures and send it to us, that's also great. As mentioned again, communications with the dealer. We'd love forward us those emails. If you got pictures, that's great. Some people, very smart tip, take pictures of the car before you buy it. Before you buy it. And then that way, when you have issues with the car afterward, you can say, this is what it looked like before. This is what it looked like after. That's a really great tip. And that a lot of people don't think about. And the dealership usually, I mean, they should have no problem with you taking pictures of the car, honestly. Okay, you should also give us estimates from the mechanics. We like to see those. And again, receipts for repairs. So let me take a quick look. Oh, great. We have a question. This is so exciting. Thanks, Ryan. Do you recommend getting an independent inspection by a mechanic before buying the used car? That is a great question, Ryan. It depends on your means. You know, we have a handful of clients who don't have enough money and they don't want to pay out of pocket for an inspection by an independent mechanic. If you can, you should. Why not? Like, right? Like getting a second opinion can't hurt. But you're not under an obligation to do that. Like if you don't get an inspection and then something happens to the car, that's not on you. Again, it depends on what the issue is. If the car is unsafe and you did not get an independent inspection, just for whatever reason you didn't, that's not your fault. It's still the dealer's fault that they sold an unsafe vehicle, right? So it's your choice. It's your choice. But why not? A lot of dealerships will sell um, certified used vehicles. Those ones tend to have really good inspections done on site. They cost a little more, but you're paying for that. You're paying essentially for that inspection that's already done. So it's your call. It's your choice. Next question, Ryan, you have so many good questions. Do you have any tips for getting around the properly negotiated as is clause? When purchasing a used car to make a valid. Well, the way you phrase that makes it sound like you're trying to work your way around it, which is probably not advised. Honestly, the way to work around it is to not agree to it at all. If the dealership presents you an as is clause and you don't like it, you don't feel comfortable with it, you don't want to, just say no deal, walk away. And let me tell you how hard the dealers will try to make you come back. They might even say, you know what, we'll just let this one go. You can, if you pay this much for the vehicle, we'll just go ahead and let you purchase this car. So honestly, there's no sneaky way to get around it. We have a lot of good, honest clients that honestly, either the dealership handed them a stack of paperwork and did not have a conversation with them about you're signing this or signing this. This is what it means. That will have a claim in that case because they didn't have the conversation to waive the IWM, the implied warranty merchantability. So that's an occasion, an honest occasion when that would occur. So I hope that answers your question, Ryan. And Alysa, I have a question for you before we go. Let's say I have lemon, and it looks like it's heading to arbitration, but I'm a little nervous. I don't know if I want to go by myself. How would you recommend, what occasion would it be a good idea to get maybe an attorney to help me out at the arbitration? What do you think?
I think a good instance where you would want to get an attorney to help you with the arbitration is if you do have like a particularly difficult case. So if it's not as simple as, oh, this part's broken in the vehicle, it's clearly a manufacturing issue, and where you have concerns about being able to argue your side, it's not a bad idea to seek out resources like NWCLC or other resources that we are able to point you to help give you legal representation.
Thing that I guess most people don't think about if you're going to an arbitration, if you're just generally shy, you're a fearful person, or maybe English is not your first language. I'm sure you're hearing this webinar translated, which is awesome. Then maybe getting an attorney is a good idea just to help them advocate on your behalf. Okay, so thank you for attending our webinar. Visit us at our website, nwclc.org. It's getting revamped, which is super exciting. So check back in a month or two and you might see a whole new website. We're also on Facebook and Twitter, and there are our office hours. We don't pick up the phone outside of those hours, but if you leave a voicemail, we'll get back to you as soon as we can. And there's our number for our intake line. Thank you all very much. Hold on just 1 second here. I might have some closing remarks that I've misplaced. It'll be just one moment.
Got another question from Ryan. I tried to answer in the chat, but so
really?
the income, yes,
Okay.
the income threshold for NWCLC representation. So typically when you contact us, we'll have an intake discussion with you and we'll help you determine what federal poverty rate you might fall in, and we take cases 500% and below.
Mm-hmm. Yeah, and it'll depend on your case, depends on what legal claims we can put together, but if there are Consumer Protection Act claims, which is a lot of legalese, but if it falls under that, if I can put it under that law, then we can charge you, that sounds weird, but we can put together a contingency fee agreement, which means you don't pay our attorney's fees like monthly. We get our fees from the settlement, which is really great because a lot of our clients are low income and it's expensive to pay for an attorney monthly. But if, it depends on the case. Sometimes we also do sliding scale fees. So based on your income, we'll have reduced rates for an hourly fee. So check our website to watch recordings of the other sessions in our webinar series. We have sessions on student loans, mortgage, foreclosure, bankruptcy, and more. They are all available 24/7 at nwclc.org/COVID-19. Hopefully someday we will update that link because COVID will be gone. All right, if you're seeking legal representation, you're welcome to contact NWCLC to apply for our services. We are able to provide help for those of low and moderate incomes in Washington State. You can apply online at nwclc.org/gethelp or by phone. We have our phone number right there on our last slide. Thank you for joining us tonight and take care.